Hi folks, I hope you're all well. I'm just recording the videos for this week. The first video we have is about remand, conferencing and boot camps, and I'm just going to talk through these very quickly. So when we're talking about remand, we're talking about pre-sentence remand, which means they've been charged with an offence and the court has decided that they're either at risk in the community or they are a risk in the community, so they decide to keep them on remand. About 50% of young people in detention are on remand at any one time. That's about, in comparison with about 24% of adults. Now, interestingly, that's gone up quite a lot in recent times, and there's a couple of recent reports that talk in more detail about that. I'll talk about them in a moment. The number of young people on remand has fallen in the past, but at the moment it's actually rising quite a bit. About 89% of young people on remand are between the ages of 14 and 17. Typically, the length of time that an Indigenous young person is longer, the Indigenous young person spends in remand is longer than a non-Indigenous young person. And the average total time on sentence was about 35 days. Now, importantly, a lot of young people who are in remand actually don't receive a custodial sentence when they appear in court and they are actually sentenced. We can see here the extraordinary difference, particularly between Indigenous young people, which is this line here, and non-Indigenous young people down the bottom. The numbers of Indigenous young people in remand are staggering in comparison with how much of the population they actually constitute. There's a whole bunch of different drivers of remand for young people, and this is all outlined in a really good report by Kelly Richards and Lauren Renshaw, Bail and Remand for Young People in Australia. It's quite a long project, so I've pulled out a few snapshots. There's things like, obviously, rates of offending. There's a lot of complex needs of young people that are not being met. Young people are not applying for bail. There's a lack of access to legal representation, overall judicial attitudes and whether or not they are particularly punitive, and of course community attitudes similarly. Long court delays sometimes means that the remand is their only option. Difficulties locating responsible adults or parents or guardians to support young people's bail applications. There's pre-court decisions that are made, around police, that sort of thing. Risk aversion, the influence of victims' rights, and whether or not the right of the victim, weighs heavily over the right of the young person. Inappropriate or arbitrary use of bail conditions, breaches of bail, police performance measures like KPIs, policing practices like hotspots and things like that, administrative errors, lack of access to programs on the outside of remand system, and of course the influence of therapeutic jurisprudence, which is where the legal system in itself becomes a form of rehabilitation. So there's a whole bunch of different areas that push young people towards remand. When we're looking at different types of conditions when they aren't put into remand, the most common ones in terms of bail, curfew, residing as directed and specified, obeying reasonable directions, and of course non-association with particular people. There's a lot of impacts of remand on young people: separation from family and community, of course, disruption to education and employment, association with other young offenders who are sometimes better equipped with criminal skills, being inappropriately held in police lockups that are not designed to meet young people's needs. This actually happens quite a lot in Queensland, particularly in the last few years where there's been an overabundance of young people in remand. Not being able to access therapeutic programs, of course, on the outside when they're released. Being more likely to receive a remand period following a future court appearance rather than a period of detention. Being more likely to be given a sentence of detention than those young people who receive bail. So all of those things are really important issues. There's some really good research about bail, of course, in the Richards and Renshaw project, as well as this great one by the Youth Justice Coalition. Most importantly, I think there's a lot of young people in custody for breaching bail conditions, and about almost 10% of the young people that they surveyed found that they just couldn't actually meet their bail conditions at all. So these types of things are actually really significant because we're effectively setting young people up to fail if they can't meet their bail conditions. People talk about remand as being parking spaces for young people. It has a significant impact on Indigenous young people in particular, and they're far more likely to reoffend than other young people who are diverted away from remand in different ways. In terms of youth justice conferencing, I'm not going to say a lot because there is a whole lecture on this. I just wanted to quickly say that, you know, it's about restitution, injury repair, and offender-victim reconciliation overall. Most importantly, there is some research that says it's pretty effective in terms of when a young person comes into a youth justice conference, in comparison with a court appearance, they're less likely to reoffend if they go through a conference. So that's just basically the main point. That doesn't mean it's not problematic. There are problems with conferencing, but it does at least give you an indication that it is a little bit more effective than sending someone to court. So in terms of problematizing it, there's a lot of officers that don't know they're available, yet officers are the main people that refer young people to conferences in Queensland at the moment. There is no court-referred conferencing. It requires admission of guilt. It fails to provide legal protections because lawyers are not allowed in the room. It can be intrusive and can result in harsher outcomes. Sometimes meeting the needs of the victims overrides other basic legal rights. Not suitable for some offences, although a lot of different types of offences have been conferenced, including sexual offences. Trivial matters going to conferencing. So Hennessy Hayes, for instance, told me about an example from his research where a young person was being conferenced for a $2.80 train fare, and the parents just walked into the room, threw the $2.80 across the room at them, took their young person and walked out, like stormed out of the room, because they were furious at the fact that they wasted an entire day of work to come in for a conference with Queensland Rail. Compensating for group offences, I think I've talked about this already, where one young person is actually the person that committed the offence, and there's 7 other young people that were just standing around, and of course all of them are conferenced, and they're very unlikely to admit guilt in those circumstances because they don't actually feel that they are. So overall, though, it seems that research suggests that people perceive these processes as a fair and better alternative to supervision, and of course much better alternative to detention in various forms. At the moment in Queensland, we have boot camps as another option. An option that young people can go to either before or after court. In Queensland, the 2 options we have are boot camps for those young people who have committed an offence, and also boot camps for young people who are at risk of committing an offence, who haven't actually offended at all yet. There is, and I'm only going to touch on this, there is a little bit of research around boot camps, but for the most part, as Wilson et al., that's a meta-analysis of 32 robust research studies of militaristic style boot camps. This common and defining feature of a boot camp is not effective in reducing boot camp reoffending. So when this common and defining feature is the military way of setting it up, they found that if a young person is in a boot camp, it's beneficial for the time that they are in the boot camp, and then it's not beneficial after that, usually, because they go back to their environment where the offending started. Wilderness boot camps were also found to not reduce recidivism overall among participants. Although boot camps may seem like a good option in terms of distilling discipline and so forth, this is not necessarily the case when it comes to actual outcomes for young people. It seems like at the time that they respond really positively, but over time it's obvious that those results they're not enduring, they don't continue after that young person has finished in the program. Well, that's the first video done and dusted. I will get on to the other ones now. See you soon. Bye.